Good afternoon and welcome to this webinar on GDPR compliance and looking at where we've been in the last 2 years in terms of GDPR. So today I'm going to talk a little bit about how to achieve compliance, how to maintain your compliance, and then we're going to look more specifically at one of the biggest problems we have is resources, and particularly in relation to DPOs. In reference to that, if you go into the handout section on this webinar, you'll find that there's a complete guide to hiring a DPO, which you can download to actually support the information that we're providing in the webinar. So without further ado, let's get on with the webinar. Let me introduce myself. My name is Nikki Whiting. I'm Head of Compliance at Bulletproof. I manage a team of PCI, ISO and GDPR consultants. And today I'm going to use my 20 years experience in the IT and cybersecurity industries to help you understand the requirements of the GDPR. I know it's a pretty dry topic, but I've developed quite a few training courses over the years, and I'm certain by the end of this you'll not only understand what's required, but also know what to do in terms of implementation, assuming you haven't done that yet. Let me tell you a bit about the Bulletproof data privacy team. Our consultants are all, as a minimum, certified GDPR practitioners. We've also got amongst us a couple of certified data protection officers as well. And the whole team has worked with lots of different clients across lots of different industries on GDPR projects over the last few years, including GDPR gap analysis, GDPR implementation, and our outsourced DPO service. As well as having that excellent knowledge on GDPR, our consultants also have really good knowledge on cybersecurity and other compliance standards such as ISO, PCI, etc. So they're able to give that whole holistic approach when they're working with GDPR customers and can give advice just beyond the law and the regulation. Let's have a quick look at the agenda now. We're going to look to see where we are 2 years down the road from when GDPR was launched. Look at what companies should have done in terms of what implementation tasks should have happened, and also what companies that have already done their implementation should be doing now to make sure they're maintaining their compliance. We'll also have a chat about resourcing issues, because that's a big problem in most organisations and one that actually holds up generally implementations and also maintaining compliance. And finally, at the end, I will be handing over to my colleague, Luke Peach, one of our certified DPOs, who is going to do the Q&A section with us. Let's take a quick look at what's happened in the last 2 years since the GDPR came in. So 2 years on, GDPR compliance is still actually quite poor, certainly in our experience anyway. Obviously we work with a lot of customers and we see generally the starting point of their journey on GDPR, but we also do talk to customers that maybe have done a little bit of work, but even then we do find that generally the level of compliance is poor. It's interesting that over the years, as we've started to work with companies on GDPR, that the level of maturity of the companies that we deal with hasn't really changed. They've still got the same old problems, the same things they haven't done. And I think some of this is down to the fact that, the previous Data Protection Act was much more of a tick box exercise with a lot less accountability. So people didn't have the processes and procedures in place, and they're not used to that. Another problem that we're beginning to see now, sort of 2 years down the road, is that there are some companies that did make a real concerted effort to get themselves compliant with the GDPR. But what's happened is that whilst they made a big effort sort of either just before 25th of May 2018 or immediately afterwards, what's happening now is that they think they're compliant and they've kind of taken their eye off the ball. So now they've got a bunch of policies and procedures, and they've got some data flow diagrams, they've got their Article 30 records of processing, but they've not kept them up to date. So we're beginning to see more and more companies like this that have just not maintained their compliance going forward. And that can be for any number of reasons, lack of resource or, other projects taking priority, etc. And of course, the one thing that hasn't gone away, even if the hype has about GDPR, is the fact that we're still getting breaches. And you can see from that slide that there's been over 22,000 breach notifications since the GDPR came into effect. So it's just as important now as it was when all the hype was happening back in May 2018 that suitable levels of compliance are put into place to help protect against those breaches. And another thing we need to think about with 2 years down the road is Brexit. What's going to happen to the GDPR? One thing I will say straight away is that it's not going to mean that GDPR goes away. That common myth needs quashing. The GDPR has been enacted into UK law under the Data Protection Act 2018, and that will still be the law on January the 1st, 2021, when we officially leave the EU. At the moment, we're in that transition period, so we still come under the EU in terms of the GDPR. There will be some changes, but the difficult thing is at the moment we don't really know what those changes are going to be because the negotiations are still ongoing between the EU and the UK. So all I can really say in terms of Brexit is you need to keep a really close eye on the ICO website and listen out for what's happening, because until we know the outcome of those negotiations, we won't know what we'll need to do from a GDPR/Data Protection Act point of view. I mentioned earlier that we've seen a lot of companies where there's been very little, if any, progress towards achieving compliance against the GDPR. So what are some of the reasons behind this? Well, probably the most popular one is lack of resource. It can be really difficult for businesses to find someone in the business who's got time to actually spend on a GDPR implementation or even just maintaining the GDPR compliance. It's also really difficult to get other people in the business involved in that process, which you do. You can't do it on your own. You need input from departmental managers, senior management, etc. And even people that do the day-to-day job. There's also the inevitable costs that can arise as a result of a GDPR project. For instance, you might need to bring in extra resource from outside if you haven't got the skills in-house, and that costs money. Equally, you might have to implement some technical controls. So for instance, if part of your risk assessment you identify that you're not sending personal data securely over email, you might need to look at some encryption technology for your email. That'll cost money. Another big problem area for all organisations is lack of skills. There's lots of organisations out there, and I would say the majority that we work with, where there are no in-house GDPR experts, or even people with a vague understanding of GDPR. As a result, you often have to bring those people in. If you're going to bring them in full time, that can be expensive, they're difficult to find, so you might end up using a recruitment consultant, which again is going to add to your costs. So those skills aren't the easiest thing to find, and it can be time consuming to find them. Then there's the idea that lots of businesses seem to have, is that, well, they won't come after me. I'm just a small business. They're not interested in me. And to a certain extent, you can understand where that mindset comes from, because if you think about the fines that have been announced by the ICO, well, the ones that have at least got in the press, they've been referring to things like BA, which was fined 183 million, and Marriott, 99 million. So, your perception as a business owner might be, well, they're big organisations, they're not going to target me. But perhaps less well known is that the ICO has already fined a small pharmacy in North London £275,000. Now, obviously, that's a lot less than the BA or the Marriott fine, but as a small business, that's a lot of money. And when you think that under the old Data Protection Act, the maximum fine was £500,000, that fine on that small business is over half that. So it gives you some indication as to the change in scale, the increase in scale that we're now beginning to see with these fines. Another area that we always see in businesses is other priorities coming along. Businesses are busy. Most businesses don't have a lot of slack, and so a big customer order comes in or a large tender comes through the door and it's all hands to the deck, and other business priorities take over. As a result, GDPR gets put on the shelf and ignored. And we've seen that with a lot of businesses, I said earlier, where they started doing really well. They got their GDPR project in place, they implemented, got everything in place, and then they just left it because other business priorities came along. And finally, another really, really important thing with GDPR, if you're going to implement properly, is you need senior management buy-in. And if you haven't got that, it's going to be really difficult to actually make sure you've got the resources you need to actually get up to a suitable level of compliance. That compliance really depends on senior management being accountable and taking ownership, and it needs to come from the top down. They need to drive it. It's not going to work if you've got a senior manager who basically ignores all your policies and procedures because it's too difficult. They will set an example for other staff who will then take the same attitude. So what happens if you're not compliant? And let's face it, there are lots of companies out there that aren't compliant and have taken the position that they're not going to bother. And with all the hype that came about when the GDPR was launched, we constantly had the press telling us that we were all going to be fined millions of pounds. The perception is very much that it's all about the fines. But it's much more than that. And in fact, in some cases, I would say the fines are the least of your worries. The first obvious risk you've got is that you've got this increased risk of data breaches. If you're not taking data protection seriously, you're not going to make sure that your personal data is protected to a good level. And as a result, you could end up having a data breach. Equally, if you're not taking it seriously, you're not training your staff can accidentally cause a data breach because they don't understand the importance of protecting personal data. We've already talked about the fines. But as I said, I don't think they're necessarily the only thing to worry about. Reputational damage. Think about the effect it can have on your company if their name is published on the ICO website as one of the companies that's had a breach. Also, sometimes with a breach, you have to notify the data subjects. How's that going to look if those data subjects are your customers? And another thing to think about is what impact is it going to have in the future? A good example of this was TalkTalk a few years ago. They had a data breach which was, I think it was about 157,000 customer records were breached. And the impact on their business was quite significant. Not only did they suffer an 11% drop in their share price, but they estimated that they lost 101,000 customers. That's a significant impact on your business. Now, someone like TalkTalk's quite big and they could probably deal with that. But if you're a smaller business, that's going to be really damaging. Also, if you're not compliant, you are missing out potentially on competitive advantage. Increasingly now, businesses, particularly customers, are asking their suppliers to fill in compliance questionnaires. They want to know that there's a good level of GDPR compliance and cybersecurity compliance there. There might be a tender process, and we see this a lot these days as well, where you have to give details of your GDPR compliance. So you're on the back foot if you haven't done it. Equally, investors, so large and small these days, are beginning to look at more detailed due diligence, which includes not just financial due diligence, which has always been the thing they've looked at in the past, but also cybersecurity and GDPR, data protection, data privacy. And not having those safeguards in place could mean that you don't get funding. Finally, the other thing to think about when you're thinking about GDPR compliance is that if you did have a data breach and the data subjects were impacted in some way, they have the right to take you to court. And they're entitled to compensation, potentially. Equally, if that does happen, you're going to have to pay for some kind of legal representation. That can be quite expensive. Let's take a look at what companies should have been doing. So let's take a look at what should have been done. As I said previously, probably one of the key things you need to make sure with any implementation project for GDPR is that you've got senior management buy-in and that they're held accountable for the GDPR. If that isn't there, then you're on hiding to nothing. And you won't be able to achieve the next step, which is to identify and allocate resources. Have you got suitable budgets in place? Have you got the right people? Do you need to bring people in? The next step really is to look at what you've got in place already and compare that to what the GDPR actually needs you to do. We call this a gap analysis. And it's a really easy way of being able to identify what your implementation project steps are going to be. So once you've done that, you'll have an action plan in place. You can create your project plan from that, you can allocate resources to that project plan, and you can make sure you start to address the gaps. At some point during your implementation, even if you haven't done some training up front for maybe some of the key people involved in the implementation project, you're going to have to do training for all your staff. Everyone's going to need some awareness training of GDPR so that they understand what their responsibilities are, what personal data is, and how they can prevent data breaches. They'll also need to understand what to do if there is a data breach, or if there's a data subject access request. They need to know what to do. They need to know what procedures to follow, and so you need to make sure you've trained them. And finally, once you've done all that lovely work, you need to make sure that you actually maintain your compliance levels. It's not a case of you've finished the project and you can just leave it now and ignore it for the next few years. You can't do that. You have to keep things up to date. You have to make sure your records are being kept up to date, that your documentation is regularly reviewed, being data mapped, etc. And that's why it's really important that you've got someone in the business that's got ownership of this. Because if nobody takes responsibility for it, it will just die and get left on the shelf. So looking in a bit more detail about an implementation project and what you actually need to do, we've got 10 implementation tasks here. The first one's data flow mapping. And it's a really key task, and it's one that I always suggest to companies that they do first. And the idea behind this is that you map the flow of personal data through your business. So you identify the processes within your business that are processing personal data, and then you map where that data comes in, who it goes to, who accesses it, where it's stored, if it's sent off to other organisations, who does it go to, if it's sent outside of the EEA, where is it going, so that you understand completely what's happening with that data. And it gives you a really important picture of all your data and how it's moving. To give you some examples of when I've done data flow mapping with companies, one of the things I tend to find is that if you just talk to the departmental manager rather than actually talking to the people that do the day job, you get very different answers as to how and where data is being stored. I remember going into one company and we were talking about storage of passport information that they used to verify that people were, able to work in the UK. And it was quite funny when I spoke to the people that actually did the job, because they told me that, oh yeah, well, we keep a copy of that in Dropbox so that we can easily access it from home if we're working from home. And the departmental manager was completely oblivious to this. He had no idea that that was happening. So capturing those little nuggets of information is really important as part of your data flow mapping. So don't ignore the people that actually do the job. The second thing that will quite naturally fall out of your data flow mapping is something called your Article 30 records of processing. And the idea behind this is that you're keeping a record of all the data you're processing, where it's transferred to, what your lawful basis is, what security measures you've got to protect it, how long you're keeping it for. And that just is quite easy to put together once you know where all your data is and what's happening with it. And you'll find there'll be some blanks, and then that's decisions that you have to make and go away and find out about. The next thing you need to think about is risk and risk management. Being able to assess the risks to the business of having a breach, etc., is important, but equally, if not more important, is actually being able to assess the risk to the data subjects. So how is what this activity that we're doing impacting on the data subject, and what would happen if there was a data breach? So putting in place a risk framework such that you can then have a consistent methodology for assessing risks to our data subjects and to the business in relation to GDPR was really important. The next thing to note is that you need to think about identifying the lawful basis of processing any personal data that you have. Basically, if you don't have a lawful basis to do so, you shouldn't be processing that data. It can be quite difficult sometimes to identify what that lawful basis is, and you might need to get some advice and some of that. And number 5, data protection impact assessments. This kind of links back with number 3 with the risk framework. The data protection impact assessment has to be carried out for processes and activities that may present a high risk to a data subject. A good example of this is things like CCTV, where you could be monitoring quite a lot of people in a public area, say if you've got CCTV in your car park or whatever. So the idea is you conduct this risk assessment, you consider the rights and freedoms of the data subject, and you document all of this, and you look at what controls you can put in place to actually minimise the risk to the data subject. So following on from the last slide, the next thing we need to think about is privacy notices. Now you're all probably fairly familiar with these because lots of organisations put them on the websites or even send them out with documentation and paperwork, etc. It's really quite an important document because it helps to inform the data subject what you're doing with their data. It'll include contact information for your internal person responsible for GDPR. It'll include telling them what their rights are. It'll include telling them why you're collecting the data, what purposes you're collecting it for, what types of data you're collecting, where it's going, etc., etc. There's quite a lot of stuff in a privacy notice. And as I said, a lot of companies publish it on their website. So it is your public face. It does say to people, we know what we're doing with GDPR. And believe me, I see an awful lot of company privacy notices that still reference the Data Protection Act 1998, 2 years down the road. Then we need to think about third-party relationships. If as a business you're transferring some personal data that you collect to other companies to do something with it, to process it in some way, then we need to make sure we've got contractual relationships in place with those businesses. So you might need a little bit of legal support there to make sure you've got the appropriate wording in your contracts. And equally, if we're moving personal data outside of the European Economic Area, then we need to think how we're going to do that securely. We're fine if we're moving data within the European Economic Area, you can just do that. That's one of the reasons we came up with the GDPR in the first place. But if you're moving it outside to an organised, to a country outside of the EEA, then you will need to put additional safeguards in place, whether that's additional contract clauses, it might be binding corporate rules, depending on your organisation and how it's structured. So you need to protect that data in the same way as it would be protected as if it was remaining within the EEA. The next thing to think about is governance and policies and procedures. And this is probably where there's quite a big difference between the current GDPR and the old Data Protection Act. This whole concept of accountability is much stronger in GDPR. Being able to prove that you're doing what you say you're doing. So first steps, you need to document what you're doing. So organisations might find they need to have more policies and procedures in place. So for instance, like your data subject access request procedure or your data breach procedure, so that people know what to do in certain circumstances. And finally, in certain circumstances, there is a requirement to have a mandatory data protection officer. Depends what you're doing as a business, but if you're a public body, then you will need to have a data protection officer. If you're a company that processes large quantities of special categories of data, that's the really sensitive stuff. So, you know, health information, sexual orientation, religious affiliation, even trade union membership, funnily enough, you will also need to have a DPO. Another reason for having a mandatory DPO might be if you're doing a lot of systematic monitoring of data subjects on a large scale. So to give you an example, something like the Tesco Club Card, where they're collecting a lot of information about people's shopping habits, that would be something that would require a DPO. So if you do need a DPO, you will need to appoint one, and we'll talk a little bit later about what that means and what kind of criteria you need to think about from that point of view. But you'll also need to register your DPO with the ICO. And of course, don't forget, you need to also make sure that you've paid your registration fee to the ICO. You've done your GDPR implementation. Let's look at how you maintain that compliance. Here comes the difficult bit. You've done your implementation and you might think that was the difficult bit, but now you've actually got to maintain your level of compliance going forward. You can't just let it sit on the shelf and ignore it now. You've spent money and you've spent time, so it's now time to make sure you can keep that value that you've created. You need to think about things like training. You should have done that as part of your implementation, as I mentioned earlier, but you need to make sure you maintain this. You can't just train your staff once and then forget about it, because they'll forget about it as well. So making sure you're doing regular training, at least do an annual awareness session on GDPR. But what you also might want to do is supplement that with some knowledge-based emails or some posters reminding people about things like security breaches. You might have some posters on the wall about phishing attacks. You might get the IT team to send out information about the latest attacks that they've heard about and what it means and what to look out for. You'll also need to make sure you're maintaining your records. So, for instance, maintaining your record of data breaches and data subject access requests, keeping them up to date. So if something happens, somebody needs to go in and fill that login. It's a requirement of the GDPR. If the ICO came in and wanted to do an audit on you, they would expect to see that there. Maintaining your records of processing activities. So, as I said earlier, your records of processing activities is basically all the details about the data you process, the lawful basis, how it's being retained, how long it's being retained for, how it's being secured, etc. Now, obviously, over a period of time, things will change in your business. You might start to collect some additional data. You might stop doing some processes, in which case you need to take it away from your records of processing activities. So you've got to keep that up to date. So whoever's responsible for that has got to make sure they've got good, clear communication with the rest of the business so that they understand what it is that has changed. You should be constantly reviewing your security measures as a business. So you might need to think about putting in place regular vulnerability scans, and you might do periodic penetration testing just to make sure that your security is still in place. It doesn't take very much for someone to make a mistake and all of a sudden you've got a big hole in your security. One rule change on your firewall could open things up by accident. As the business changes and new processes are implemented, you're going to have to conduct new DPIAs, and you might need to revisit some of the ones you've already done if the circumstances change. So making sure you're keeping those up to date. You'll need to be looking at risk on a regular basis. There'll be new risks that come along throughout the time that you're involved in any project. You need to make sure they're being analysed. You need to make sure they're being assessed, that actions are being taken to mitigate those risks, and that they're being reviewed on a regular basis. Data protection by design is something that's mentioned quite a lot in GDPR. And the idea behind this is to make sure that instead of bolting privacy on at the end of any project, you're actually thinking about it at the beginning. So if you're thinking about in a business implementing a new process or a new procedure, or even if, for instance, you decided that actually we need to put a new HR system in, then at the beginning of that project, when you're looking at specifications and you're looking at what's required, that's when you should be thinking about protecting your personal data. There's no good buying some whizzy HR system which doesn't secure the personal data properly, and you only discover that when you've already implemented it and trained everybody on how to use it. It's going to cost you a lot more money to put those controls in place after the event than it is if you build the whole thing into the design to start with. A bit like your records of processing activities, you're going to need to make sure you're keeping your data flow mapping up to date, because again, things will change. New servers will be added. You might change from on-premises servers moving data into the cloud. That will change your data flow maps. Different people might get involved in different processes. That will change your data flow maps. So you need to make sure these are being kept up to date. Normally what you do is you disseminate those to different departments so that they own those and they have responsibility for the processes that they manage. Equally, you're going to have to think about documentation reviews. Policies and procedures will get out of date as things change, as the business changes, as regulations change, as new rulings are made about the GDPR, it might make you want to change some aspects of your documentation. So your documentation needs to be reviewed on a regular basis, at least once a year. And finally, when I spoke about contracts earlier, when we talked about having contracts in place with your processes, etc., you need to review those on a regular basis as well. Has anything changed that might affect what's in the contract? So again, you need to be doing that at least annually. You may recall earlier I said that resourcing was one of the big problems and a barrier for GDPR projects. Let's take a closer look at some of the key resourcing issues we see, particularly in relation to the key role in the business responsible for privacy. So what happens when you need to have a mandatory DPO? What do you need to think about in terms of the type of person, how you're going to recruit them, how it's going to work in your business? GDPR is quite prescriptive about DPOs and what they can and can't do. And some of the things they define include things like the DPO must be independent, they have to have no conflicts of interest, which can be really tricky for small businesses. So to give you some examples here, if you've got a manager who has some decision-making ability to decide what kinds of personal data you're going to collect, how you're going to collect it, then they are determining the means and purposes of processing personal data. The GDPR is quite clear here that if that's the case, that person cannot be a data protection officer because it is a conflict of interest. Equally, as a lot of companies used to do under the old Data Protection Act 1998, they used to make the IT manager the data protection officer. But the IT manager very often will have some level of oversight or responsibility for securing personal data. So again, there's a conflict of interest there. There's quite a few roles that people often think they can be DPOs in, but in fact they can't. So a CEO, a CTO, an IT manager, a marketing manager, sales manager, unlikely roles that you can use as a data protection officer because there is that conflict of interest. And of course that does present the problem for small businesses where very often people are wearing more than one hat. And that's why a lot of small businesses actually outsource their data protection officer, because it's just easier to make sure you haven't got that conflict of interest and you've also then got that independence. And sometimes people from outside the business get listened to a bit more than people within the business. Another thing you need to have as a DPO or a mandatory DPO is they need to have a good, strong knowledge of the GDPR and privacy laws. So they need to have done some sort of training. They might be legally trained, but they don't have to be a lawyer. And they have to report to the highest level of management. The reason being that they have to have that clout. They have to be able to make sure that management are hearing what's going on and that management, senior management, can then do something to make sure that the changes are made in the business that the DPO is recommending. And finally, an area that's sometimes forgotten about is it's also recommended that in the GDPR that data protection officers have a good understanding of data security, IT and risk. It's all right if you're just a very knowledgeable lawyer, for instance, on GDPR, but if you don't understand, at least have a vague understanding of the technical controls that you can put in place to mitigate the effects and the risks, then that can be a problem. So getting someone as a DPO who's got good GDPR knowledge but also has a good understanding of security and IT and risk is really what you need to be effective. Obviously those kinds of people are difficult to find, and it is a problem when you see a lot of DPO roles that they are very legally focused. And that's one of the reasons why our DPOs have that cross skill set. They have that GDPR knowledge, but they also have a really good data security and IT knowledge. And they've got a good understanding of risk and how to manage risk. Other things you need to think about with your DPO is you can recruit a full-time DPO, but they are going to take holiday or be off sick occasionally. And you can pretty much guarantee that the time that they take holiday or if they're off sick will be the time when you have a data breach, because that's the way it works, isn't it? And they'll be sitting on the beach somewhere drinking their cocktail in the sun, sunning themselves on holiday, and you'll be running around like headless chickens in the business trying to work out what to do because you've had a breach and your data protection officer's not there. So you need to think about how you're going to cover that. You've got to have someone else in the business who can really hold the fort while they're away. As I mentioned earlier, DPOs are quite difficult to find because of the skill set, and as a result, their salaries are quite high. And because they're difficult to find, recruitment costs can be quite significant as well. So that can have quite a big impact on your business in terms of the overall cost of having a DPO. And then you need to think about, is the DPO a full-time role? It might not be. If you're in a smaller business, it might be that actually the functions of the DPO can be carried out part-time. But then that leaves you with a question. Well, if I employ them on a part-time basis, I've got an additional problem above holiday and absence. I've then got half the week when they're not here. What am I going to do when they're not here? And the other thought process is, well, okay, let's make them full-time. But if you make them full-time, what are they going to do with the time that when they're not doing the DPO role? Because you've got to make sure that they're not doing anything that conflicts or is a conflict of interest with their DPO role. So it can be quite tricky. Of course, not all companies need to have a DPO, but I think the important thing to say here is that even if your business doesn't need a DPO, you can't take the attitude that, well, in that case, we don't need to worry about it. There needs to be somebody in the business who is managing data protection, who takes ownership of it, as the go-to person, if you like. And they won't be called a DPO, but they might be called a privacy officer, for instance. And they too, like a DPO, needs to have a good understanding of GDPR and privacy law. Equally, as like the DPO, they'll need to have at least some knowledge of data security and IT, as well as risk. Because they'll be performing a very similar role to the DPO. The only difference really, in a lot of cases, will be the title. You also need to think about how your privacy officer, or whatever you decide to call them, is going to function within the business. Unlike a DPO, this person doesn't have the constraints on them that are a requirement under the GDPR for DPOs. So they can have multiple duties. You don't have to worry about the conflict of interest. But you have to think about how that's going to work. Are they going to get dragged into a number of other projects, meaning their privacy work gets put on the sidelines, and then it doesn't happen? And then we're back to this situation where your compliance levels just start to drop off because things get out of date. Equally, a data privacy person won't necessarily report to senior management, so they might not have the ear of anybody senior. They might not have the clout in the business. They might not be taken quite seriously as a data protection officer. So it might be difficult for them as an individual to actually get changes made if they're not listened to, if they've not got the suitable levels of authority to make other departmental managers do things. You're still going to have the same problem as you have with the DPO when it comes to things like holidays and absence cover. So you're going to need to think about how you're going to address that. You're going to have a backup, someone who can hold the fort while your privacy officer is away. And a bit like a DPO, whilst not as expensive, a privacy officer will be quite hard to find because the skill set is just generally quite hard to find. And if you can't find the skill set and you decide, well, maybe we'll train someone in-house, that's fine. But you need to bear in mind that they're going to have some professional training to make sure that they are suitably qualified and are well armed to deal with any issues that you're going to encounter. So there's lots to think about here in terms of whether you've got a DPO or not. So I think you can probably appreciate from the couple of slides prior to this that it is actually quite tricky when it comes to recruiting DPOs, and there's lots of things to think about. And that's why a lot of companies actually decide to outsource their DPOs. It just makes it easier. And that's why we've put together a package of offerings for our customers that is tailored to their individual requirements. And they offer benefits such as our DPO portal, which is a central repository that they can use for storing their policies and procedures. There's a facility in there to record data subject access requests and record breaches, etc. So they've got everything in one place. It makes it much easier for the person who's responsible within the business for privacy to access things. And also, if they're working with us on a DPO service, we've all got access to the same set of documentation. We also have partnered with Edwin Co LLP, which is a legal 500 law firm based in London. That just gives us that ability to go to them and get legal advice. Obviously, our consultants can't give legal advice, they're not lawyers, but we can get that legal advice when it's required from Edwin Co. And also, as I've said before, having capabilities in your DPO or your privacy officer of understanding more about cybersecurity and risk is actually a benefit to your business, because it helps to make better decisions, to understand what controls you can put in place. So all our DPO team are trained in cybersecurity and risk, as well as in GDPR. So it goes beyond just the pure GDPR knowledge, and that can result in better decision making. So if this appeals to you, if you think outsourced DPO or even our other GDPR services such as GAP or implementation services are of interest to you, then please do get in touch. So in summary, there's quite a lot to think about. And the first thing I'd say is stop risking those fines. Get on with your implementation project. It's much more than just fines. It's legal action, it's reputational damage that your business may suffer if you don't do something about your GDPR compliance. And don't make the assumption that small businesses won't be investigated by the ICO. They already have been, and they will continue to do so. Don't delay your compliance journey any longer. It's time to get on and do something. For those of you that have already done something about GDPR, then make sure you're reviewing your level of compliance. Make sure you're revisiting and you're keeping that up to date. Otherwise, you've wasted all that effort that you put in initially. Everybody needs to make sure that they're monitoring what's happening with Brexit, because, as I said earlier, we don't know what's going to happen yet, but there will be some changes that we need to be aware of. And don't forget that your training isn't a one-time activity. You're going to need to continuously train your staff, both in GDPR awareness, but also in basic information security awareness. And finally, start taking your data subjects' privacy seriously. Let's face it, we are all data subjects, and I'd like to think that we'd all want our personal data to be protected by the companies that we interact with. Understand the data privacy needs of your business, and make sure that you've got appropriate resources to manage compliance and maintain it going forward. Thank you for listening. I'm now going to hand over to Luke, one of our DPOs, to answer your questions. Over to you, Luke.
Right, thank you very much, Nikki. Hi guys, so my full name is Luke Peach and I am one of the compliance officers here at Bulletproof. On the screen in front of you now you can see many of my accolades, including being a certified data protection officer, a certified GDPR practitioner, and also there's a couple of other things on there that help back up what Nikki said about most of us on the team having some cybersecurity experience, with me being a Cyber Essentials assessor and an ISO 27001 lead implementer. I have a lot of knowledge in my back pocket to help apply that to your business as well as GDPR compliance. So let's have a look at some of your questions, shall we? I knew a question about subject access requests would come up. I just didn't know when. Right, can you share your view on the DSAR process or data subject access request process and the level of responses expected from data subjects and how we manage expectations? My view at the moment is essentially nobody really seems to understand any of the clear boundaries of a subject access request. And that's not just from companies, that's from data subjects themselves. A lot of people seem to think if they issue a subject access request to the company they work for, they'll be entitled to every single email that their boss has sent to HR about them, for example. And that's just not the case. GDPR does not allow you to have that sort of information. And also, people expect to have full copies of email threads, full copies of CCTV footage. And again, that just isn't the case. On a subject access request, you cannot compromise somebody else's personal security to satisfy a request unless there is a risk assessment done in the business and the risks of that individual outweigh the rights and freedoms of everyone else involved. And that, to be honest, hardly ever is the case. From a business point of view, I find that lots of companies misunderstand or misuse the exemptions on the ICO website for handling a subject access request. And ultimately, that's all down to the fact that they haven't prepared for subject access requests to come in. And by preparing, I mean a couple of things. You can have a documented subject access request process. By having that, you know exactly what type of email you will send to the data subject. You will know where to get information from. Your data maps will be completed so you understand where personal data is all over the business. And without that type of documentation, you will just be running around like a headless chicken when you get your first subject access request. Another good thing to do is run a couple of dry runs of a subject access request. Do one yourself. Or pretend to do one yourself against the business and see how well the company responds to it. See how well your process responds to it. 'Cause it's a lot better if you do it yourselves than if an actual real data subject exercise it and all of a sudden you find out your entire process just doesn't work. And in terms of managing expectations, just because someone has issued you with a subject access request does not mean they can't be contacted and can't be spoken to about these sorts of things. I've had it in the past where I've personally had phone calls with data subjects to talk about their request, to see if I can identify any ways of narrowing things down if they're looking for something in particular. And just by doing that, you're coming across as transparent, which is of course in line with GDPR. And to be honest, you meet their expectations that way and you manage them as you go along. Okay, so next up is, as a DPO, what is your experience with the Information Commissioner's Office, or the ICO? Yes, so guys, as a data protection officer, one of my roles is to act as a sort of contact or a go-between between the companies that I represent and of course the ICO for things like data breaches or just general advice and that sort of thing. And you know, I mean, from the get-go, let me just say the ICO are fantastic. You know, if you go to their website, they publish everything they do in terms of any actions they take against businesses, so you can read and get lessons learned from them. They have excellent guidance on all things like data subject rights and data breaches, and they are just a free online bank of knowledge, which, you know, if you need some bedtime reading and you want to brush up on your GDPR-ness, that's probably where I would point you to. That being said, there are a couple of things. Sorry if you're listening, anyone from the ICO, but there are a couple of things that could be better. So at the moment, if you want to contact the ICO, you may find yourself in a little bit of a queue, either on their instant messenger system or on the phone. Obviously, that's not their fault. They're probably inundated with questions every day from other data protection officers and other businesses, so you do have to just be a little bit patient. And I don't think they have as many support agents as they'd like, but I imagine as time goes on, they'll correct that and that will get better. The other thing is sometimes when they do give you a bit of advice, sometimes you give them a very specific situation and you want a definitive answer. You know, what should I do here? And to be brutally honest, it's very rare for you to get a response in terms of you must do this and you must do this. They will always tell you to think about this, or to compare it against the rights and freedoms of other people, or do an internal risk assessment and see the outcome, and that sort of thing. And don't get me wrong, those stances are useful. You know, more information on the website, and you know, gives companies a sense of control by doing their own risk assessment. But sometimes you do just want a definitive answer to some questions, and sometimes that can be a little bit frustrating. But my main bit of advice, guys, if you guys ever deal with the ICO, always document the advice you are given, because if you act on that advice and you're ever audited and it comes out that is wrong, you should be able to prove to them, well, I went to you guys, I asked you this question, here is the transcript of the chat, here's the name of the person I spoke to and the date, and here's exactly what was said, and obviously they will take that into their considerations. But that's my general experience with the ICO. But again, allow me to say, it is a great resource and one that every DPO or anyone even remotely either interested or involved in compliance, you should go there and check them out. Okay, so next question, guys, is a bit specific. It says we use Mimecast for our email security and archiving. All incoming and outgoing mail is automatically stored. If that includes CVs, for example, does this pose a problem? Well, to be honest, guys, it doesn't necessarily cause a problem. It just means you do have to do a bit more work from a compliance point of view. You will need to do things like make sure this is taken into account in your records of processing document, in your data maps, so that it can be considered when data breaches happen or even subject access requests are exercised. Now, Mimecast are obviously a massive business. They will also have their own GDPR compliance status, so they will be aware that they do need to help you out in certain scenarios as your processor. And one scenario in particular to highlight is these CVs and everything like that will be subject to things like your retention policies. Now, I believe Mimecast do have the ability for you to set your own retention policies in their system, so just make sure you are taking advantage of that functionality, because if not, you would not be compliant with Article 5 of GDPR that states that data should only be retained for as long as necessary. You can't just keep things anymore just in case. Again, so the short answer is it's not a problem. It just means that your compliance person or your compliance team do need to do a little bit of extra work on their side from a documentation point of view, and that you take advantage of any GDPR helpful functions that Mimecast offer. Okay, how much training do I need to give my staff and what do I train them on? So I would always say, guys, that GDPR and information security training should be something that is done as part of any staff member's induction, and thereon it should be at least once a year, twice a year if you want to be extra careful. And guys, in terms of a GDPR subject, there are three main things your staff should be aware of. The first is what GDPR is in general and why it's important. And how it affects them on their day-to-day duties more than anything. You don't have to give them a deep dive into the regulation, because at the end of the day they either won't understand it or they don't need to understand it, and therefore their brains will unfortunately just switch off at that point. So only give them the main headlines and the stuff that affects them on their day-to-day job, which leads me on to the other two things, is subject rights, data subject rights, and how to recognize and respond to them, and of course data breaches, how to recognize and respond to those as well. Just because obviously in both scenarios there are time frames involved, 72 hours to report high risk breaches and obviously 1 calendar month to comply with data subject rights. And everyone who works in compliance will know that we need every single minute of that time frame to comply with the regulation. And also, guys, from an information security point of view, I mean, that will cover all the basic things, why your password needs to be nice and strong, why you need to have antivirus software. It's good as well to thumb in all of the company policies in that information security training. So if your password policy says that, you're only going to allow passwords that are 16 characters long, then tell them during their training, refresh it in their minds, because most staff, as unfortunate as it is to say, they won't read a long, boring policy document, but they will listen to an engaging information security training session. And if you get the main headlines of your policies in there, you'll do a lot better than just handing them a document with the words on the page. And of course, the major thing in information security at the moment is social engineering and phishing. So definitely put some training on that in there, because phishing, especially even during this pandemic we're in at the moment, phishing techniques are coming thick and fast, offering people, slots in hospitals to get tests, and even some people are offering TV license refunds or tax refunds because they know it's a financial hardship time for some people. So phishing awareness will be good. And obviously, guys, with any training, if you can make it 90% professional and 10% personal, then you'll pique these guys' interest more, because you're talking to them about something that affects their daily lives. You know, when you're talking about 2FA, mention the fact that you will have 2FA, or you should have 2FA on all your social media accounts, and of course on all your online banking. And then they can see that, you know, business accounts, business data should be protected just as much as their own personal data in their own personal lives. So that would be my recommendations for training. Okay, so last question is, what other roles can my DPO do that do not result in a conflict of interest? And do they have to be legally trained? Well, I will come back to you on the first part of that question with, what are you expecting your DPO to do but compliance? If you're in a small business and you can't afford a full-time DPO, it's a lot better to have an outsourced one than give someone multiple hats in the business, mainly because, as an example, I've seen companies where the CEO is also acting as a DPO, and that of course will have contrast of interest, because a DPO must not directly impact the purpose and means of processing personal data in any way other than advising on the compliance side of things. And to be honest, guys, your compliance guy or girl will literally be involved in every department anyway. There's just a difference between working with and working for somebody. Your DPO should work with your marketing team, with your support team, and with your engineering teams to determine that all of your processes and your whole company from top to bottom are compliant. So the short answer to the question is, there is really no other hats they can wear in the business, because every aspect can potentially lead back to this conflict of interest. And ultimately it all comes down to the position of the DPO, in terms of if you have it outsourced, or if you have it part-time, or if you have it full-time, and of course the size of your business. All of those things affect the decision. And in terms of if they need to be legally trained, the short answer is no. DPOs can be self-taught, they can absorb things from the ICO website, they might even be thrust into a certain situation at work where they're named the DPO, and of course they build experience over time. However, in my opinion, I would say if you're ever looking to hire a DPO full-time, or even take on an outsourced one, that you do look for certifications, just because it's a little bit more concrete than hearsay. For example, if you came to Bulletproof, we would show you our certifications to prove that we had been on the right courses and got the right qualifications under our belt. So again, short answer is no, but you should always look for that sort of thing. Right, I hope that answers everyone's questions, guys. I'm going to pass back over to Nikki. Nikki?
Thanks, Luke. Well, that's all we've got time for today. If any of you have raised questions and we haven't actually answered them, please be rest assured we will contact you directly and answer any specific questions directly to you. I hope it's been a useful exercise to give you a bit more understanding about the journey to GDPR compliance and what's required really to keep things maintained going forward. At the end of this webinar, there's a short questionnaire which we'd really appreciate if you could give us some feedback. This is the first webinar we've done for compliance, so we're really interested to find out about how you liked it, didn't like it, and if there's any other things you'd like to see in terms of webinars around compliance. If you'd like to talk to us about our tailored packages and see how the outsourced DPO service could actually work for you, then please feel free to contact us. Our details are on the slide. Once again, thank you for your time and have a great afternoon.